This policy review covers court activity, federal legislation, regulations, and agency policy affecting tribal sovereignty, veterans, and education from May 17th to 26, 2026. The bipartisan Promoting Strong Native Families and Children Act has been introduced to strengthen tribal child welfare programs by increasing flexibility, reducing administrative barriers, and supporting culturally grounded services that keep Native children connected to family, community, and tradition. Child welfare remains one of the clearest areas where federal and state systems have historically undermined tribal sovereignty. In the courts, the Supreme Court sent Turtle Mountain Band of Chippewa Indians versus Howe back to the Eighth Circuit. The case concerns North Dakota legislative districts and whether Native voters and tribal plaintiffs may enforce Section 2 of the Voting Rights Act. The remand keeps open an important pathway for Native voters to challenge district maps that dilute tribal voting power. Another important case involves Papa Olalakahi, which moved to intervene in litigation challenging the Native Hawaiian Health Scholarship Program. The case reflects a broader legal strategy aimed at Native-specific programs by framing political and trust-based classifications as racial preferences. On federal policy, the Army Corps of Engineers approved continued operation of the Dakota Access Pipeline segment under Lake Oahe, adding conditions for leak detection, groundwater monitoring, and tribal coordination. Standing Rock leaders continue to object on treaty, water, consultation, and sacred site grounds. This remains one of the most significant sovereignty disputes involving infrastructure, land, and water protection. For veterans, the House passed the Sherry Briley and Eric Edmondson Veterans Benefits Expansion Act, which would increase compensation for catastrophically injured veterans, expand support for surviving families, and improve VA home loan eligibility for some National Guard and Reserve members. Other House-passed bills included the Veterans Community Care Scheduling Improvement Act, the Fisher House Availability Act, and the Veterans Transition to Trucking Act, addressing medical appointment scheduling, lodging support, and employment pathways. In the Senate, the Veterans Compensation Cost of Living Adjustment Act of 2026 was introduced to align VA disability compensation, clothing allowances, and dependency and indemnity compensation with Social Security cost of living increases. In litigation, a federal appeals court upheld most of an order restoring collective bargaining rights at VA, while pausing the portion requiring VA to fully comply with the contracts pending the outcome of the litigation. The case affects VA employees directly, but also carries implications for workforce stability, whistleblower protections, and service delivery. A separate lawsuit by Minority Veterans of America challenges the VA's rule restricting abortion access through the VA. The suit argues that the rule violates administrative law and harms veterans by allowing abortion only when the pregnant veteran's life is in danger. VA also proposed a rule expanding access to state prescription drug monitoring programs. The rule would clarify when VA may disclose or query prescription data to help prevent misuse and diversion of controlled substances. In education, the House passed H.R. 2616, the Stopping Indoctrination and Protecting Kids Act, also called the Protect Kids Act. The bill would condition federal education funding on restrictions related to gender identity policies in elementary and middle schools, including parental notification or consent requirements. Higher education remains shaped by federal student loan changes scheduled to take effect on July 1, 2026. These include new borrowing caps, limits on Parent Plus loans, elimination of Grad Plus for new borrowers, and fewer repayment options. These changes could significantly affect graduate and professional students, especially those from lower-income backgrounds or those entering public service fields. A multi-state lawsuit challenges the Department of Education's May 1st rule defining which graduate and professional programs qualify for higher borrowing limits. The case could affect access to graduate education beginning in the 2026 to 27 academic year. The Department of Justice sued UCLA, alleging a hostile educational environment for Jewish and Israeli students under Title VI. UCLA disputes the allegations and points to steps it says it has taken to improve campus safety and civil rights compliance. A federal judge also halted enforcement of speech restrictions on civilian faculty at West Point, finding that the rules likely conflict with First Amendment principles and the Academy's educational mission. That's it for the Policy Insight Report for May 17th to 26, 2026. I'm Dr. Eric Hannell, and on behalf of all of us at Chipco Preserve, we wish you the best.